All right, let's go on. So Martin will do the Korean cases with assistance from Sujin if she wants to come in, okay?
So please all tell me that you had the chance to read the Korean cases today. This is not going to make a lot of sense if you didn't. I want to start with the Myanmar case. And just to remind you and to help you, for those who really didn't read them, the man from Myanmar first entered Korea with a temporary visa in 1994 using his own identity. Then he returned to Myanmar in 1998, so he was in Korea for 4 years. He re-entered Korea in 2001, 3 years later, using a false name and a false passport. He lodged a refugee application 8 years later in 2009 using the false name. I think they call him B in the decision. He claims now to be the chair of the Korean chapter of the Karen National Union. Do you know who the Karen are? Okay, the Karen are an ethnic group in Myanmar who have long struggled for independence and there's been a running civil war with the Myanmar authorities for a very long time. A lot of Karen live in refugee camps across the border in Thailand. He claims he's been actively involved and acted as a leader in several political movements against the Myanmar authorities for persecuting ethnic minorities, including the Karen. I know it looks like the name Karen, but it's not, it's Karen. So, because you've all read the case, what are your thoughts about the court's decision? I'm interested to hear first, before I tell you what I think about it, and why I think this is quite an exciting case. I want to hear what you think. Be brave. Is it too hard to follow? I'll give you a couple of easy points first of all, just to get you thinking about things. If you look at the first page of the decision, it gives you a very quick summary of what happened at first instance and on review. At first instance, the Immigration Office rejected the claim on the grounds that the plaintiff has no well-founded fear of being at risk of persecution. We don't have a lot of information here. What more would you like to know? Well, first of all, it raises the question for me, does this mean that at first instance his credibility was accepted? I'm not sure. We don't have enough information to know. When you look at the review, you find the same thing. Not having a well-founded fear of being at risk of persecution. Again, I'm struggling to know whether his credibility had been accepted. Because what happens in the trial court? It's quite clear that his credibility is not at issue in the trial court. They accept his claim. I think that what has happened here is that at first instance and on review, his credibility was accepted, but nevertheless, probably because of the passage of time and maybe because he'd been back to Myanmar, it was considered that he wasn't at risk of harm. This would explain why the court doesn't have any concern about credibility at all, because there are some credibility problems. The court doesn't deal with those, and that's fine. It's entitled not to. The court can accept credibility just as easily as any other decision maker can. That's fine. What does it do at the top of the second page, though? The court added in its reasoning that a refugee claim can be recognised if a refugee is at risk of being persecuted as a consequence of his or her act, such as expressing political opinion in the country of residence after leaving his or her country of origin, even where the refugee provided the cause for being at risk of persecution in order to receive protection as a refugee. They were not prepared to find what we would call bad faith. This is a serious issue in refugee law. Suppose I'm here in Japan because I claim to be at risk of being harmed by the New Zealand government. And I go and stand outside the New Zealand embassy in Tokyo and hold up big banners criticising the New Zealand government. And then I turn up in front of a Japanese immigration officer and show him photos of me standing outside the New Zealand embassy deliberately waving banners. And I say, there you are. Now I'm at risk and you've got to give me refugee status. There are very strong policy reasons for not letting somebody create refugee status for themselves. It cannot be open to the claimant to decide whether or not they're going to be a refugee and deliberately set about making one. But the really difficult issue is that this overlaps with a number of rights. Actually, me standing outside the New Zealand embassy holding up a banner saying the New Zealand government is terrible and persecutes me, why am I not allowed to express my political opinion? I have a right to. Freedom of expression, freedom of thought, conscience and belief. These are the very rights I have left New Zealand because I couldn't exercise them there. I must add the New Zealand government doesn't persecute me, but I'm just using this as an example.
Just unpaid.
Yeah, when we talk about pay is a different issue. But you can see that there is a very problematic overlap between the right of somebody in a country of refuge to perform and manifest their rights. And on the other hand, cynically, we call it bootstrapping, pulling yourself up by the straps of your boots. It's an old English expression, but it means cynically creating a refugee claim where one did not exist before. It's a troubling overlap, and most countries in the world do not accept that you can refuse refugee status because of bad faith. Now, this seems to be what they're saying here. It doesn't matter that this man is undertaking activities for a Karen activist organisation in Seoul. They're not going to say that that is bad faith. And I'm really pleased at that. That's a great and correct outcome. And I say this, I need to tell you, actually, New Zealand is one of the few countries in the world where we do have bad faith in our legislation. I have to refuse to give somebody refugee status if they have acted in bad faith. It's not something we like to do. We restrict it as much as we can. We're not in the business of trying to send genuine refugees home. And I think the real solution to it, the way to prevent people cynically creating refugee claims, is to deal with it as an immigration issue, not a protection issue. So, okay, if you're going to cynically create the grounds for a claim and we're compelled to give you refugee status, that's lovely. And we're not going to send you back to your country, but do not expect to get a residence permit here. Maybe we give you a work visa. Maybe we just tolerate you here. But no residence, and maybe even no, you can't be joined by your family. We will respect the non-refoulement obligation, but we have to do something about the bad faith side of it. These are difficult issues. Korea's outcome here is a good one, and I applaud the approach taken by the courts.
Be interested to see if everybody got the thoughts on bad faith.
Yeah, what do people think? Is a bad faith policy a good thing or a bad thing?
You can all see it's very difficult, I'm sure. It's a question, really, there's a small jury here, so I'm just putting it out to you.
Okay, I've committed an act of bad faith. I didn't have any grounds for refugee status, but I've gone and protested outside the New Zealand embassy, and now I've said to you, you've got to give me refugee status. Are you going to do it? Put your hand up if you give me refugee status. So your answer depends on how badly I'm going to get hurt. Well, look, your answer is quite a good one, because when this bad faith policy was first developed in New Zealand, the tribunal that made the first bad faith finding, it was very careful to say, oh, and we find he's not at risk anyway. If you're going to find that he's not at risk anyway, why are you wasting time with all this stuff about bad faith? Just decline the claim as not well founded. Let's take the bull by the horns, as we say in English. Let's assume if you're satisfied that if I go back, I will be thrown in jail and tortured. Now, before I cynically went along to the embassy and held up protest banners, which I don't really believe in, I admit to you, I only did it to get refugee status. But yeah, if I go back now, I will be harmed. What are you going to do? Hands up if you give me refugee status.
Yeah, 1. Yeah, good. 2, 3, 4? No.
4?
4.
4 of you would save me, the rest of you would throw me to the dogs.
Yes.
Well, yeah. No, it's not a silly answer, because actually that kind of is what I was suggesting before. This is really an immigration problem. And I've only done this cynical creation of a refugee claim so I can get an immigration solution. So hurt me by stopping my immigration solution. Don't withhold non-refoulement, but deal with it as an immigration issue. And the countries around the world that have done this, I think it is a much better solution than what New Zealand has done.
Yeah, New Zealand can get to that. That answer is a good one, because it's about surrogate protection, refugees. And you don't have to give people long-term permanent residence. You can have a situation, which used to actually happen in New Zealand before this law change, where you just give person, for example, a 1-year rolling work permit or visit permit. And ministers usually can do that sort of thing. And there were 1 or 2 cases in New Zealand before that. That's how they solved it. So you're really giving them most of their refugee rights, but you are just doing it on a reviewable basis of 1 year. And there's nothing that's correct in refugee law. And that's why I must admit, when the New Zealand Act tried to ban it completely, I was quite strong in my in my discussions with them, that you're just going about it the wrong way. For exactly as Martin said, there's a solution to this problem, but it has to be a migration one, and it's not a breach of the main thing was you're not breaching the Refugee Convention, or you're legal on both counts. That's really what.
Yeah, yeah. I've just taken a note of the names of everybody who would have thrown me to the dogs. No. I'm ashamed to say, really, New Zealand pretty much invented this concept. way back in the early 1990s in a case called Re-HB. The man in New Zealand was an Iranian, and he had been declined refugee status. So he went on television, and he claimed on television that he had had possession in Iran of a copy of Salman Rushdie's book, The Satanic Verses, which at that time, and he had a copy with him, and he held it up to the cameras. And at that time, the Islamic world was up in arms about the Satanic Verses, which they considered to be, it was blasphemous. And there was a fatwa against Salman Rushdie and so forth. And so when the man came back to the tribunal on his second refugee claim, and he was asked about this, he shrugged and said, "No, I never had a copy. Don't be silly, nobody would own a copy of the Satanic Verses in Iran. But now that I've said on television that I did, you have to give me refugee status." It was completely cynical. And the tribunal created the bad faith policy. Yeah. Well, let's take those one at a time. It wasn't a credibility point because he was advancing information that was actually adverse to his claim. He didn't go on pretending that he had had a copy of Satanic Verses. That might have enabled the tribunal to say, "No, you didn't, you're lying." But it still would have had to deal with the fact that he'd gone on television about it. He just sat there in front of the tribunal, and I think Allan was on the panel of the tribunal, but the decision was not written by Allan, it was written by somebody else. And he said, "Yeah, I was lying. I made it up so that you would have to give me refugee status." Now, your second point is he actually at risk? The tribunal went on to find he wouldn't have been, because it said what would have happened was this. On return to Iran, getting to the airport, into the hands of the authorities, if anybody had asked him about this television interview, he would have been very quick to say, "Look, it's not true, I just made it up. It was just a ruse to try to get residence in the West. I'm a loyal Muslim. I've never owned or even read Satanic Verses." He would have been able to convincingly tell them that it was simply not true. Iran is very familiar with people playing that game, making up stories to get refugee status in the West. And there's no country information I've ever seen that says that they punish people for doing so.
No, it was on New Zealand TV.
No, New Zealand TV.
New Zealand.
Yeah.
It was on New Zealand TV. You need one more piece of information. It wasn't actually him that organised it. It was his, not lawyer, but consultant, who, to be frank, was a fairly dubious character, a person of not ill repute, but dubious. And he organised the TV station to be there. It was his back garden where the filming was done. It was him that bought the copy of Satanic Verses, and he actually tried to appear before us, so that there's another step in these things that has come in another case in New Zealand since there, that it's not actually him that, well, it's debatable. He went along with it, put it that way. But that's the reason why we said he could go back, because, and that was the truth, this consultant put him up to it. He dreamed up the story, and he dreamed it up as a way of doing it and getting nice pay from this guy to do it. Yeah. So that's the treat, and in so many cases, that's the reality. The actual claimant isn't bad faith. And that's the trouble that Martin and I have with New Zealand legislation. It's a bit blanket. And I think I mentioned to you when I was doing the first course about these very reverend ministers bishops and so forth of one of the well-known churches in New Zealand, who went along with a guy who was on a starvation program and while he was in prison for the detention. And it was them that was putting him up to it more than the guy himself. And so the ones that should get the get the rap over the knuckles for the bad faith are the bishops and the people who naively went along with this and perpetuated the cause.
We could look at stripping citizenship from all the bishops. Look,
it's a very good issue to deal with.
I'm delighted that it's in this case because it gives me the chance to point out to all of you that New Zealand is not perfect. We don't have all of our refugee law exactly as I would like it. We have contentious and difficult things as well. So if we pick holes in your country's refugee policies, you're not alone. We pick holes in our own. I want to turn to one last issue in this decision, which is an oddity. When this came to the trial court, what was the first argument raised by the state? It said, "You got no jurisdiction to hear this case because this man claimed refugee status under the false identity of Mr. B, and he can't now appeal in his own name, and so there's no jurisdiction." Well, I am thrilled that the court treated that with the derision that it deserved. He might have lodged his refugee claim in the name of Mr. B, but by the time a decision was made, they were most certainly dealing with the appellant in his real name, and the decision was issued in his real name, and the trial court was very quick to say, this is just rubbish. This man before us is the man who this case is about. And the fact that he may have used a false name at an early stage of the proceedings does not matter at all. This is good stuff from the judge. Iran. We have done so many Iranian cases. I actually enjoy Iranian cases because they're almost always they are well-educated, intelligent people who have got wonderful stories. Assessing credibility is very, very difficult, and they're charming people. They are really lovely people to deal with, you always have a good intellectual challenge when you have got an Iranian case. Conversion to Christianity. The plaintiff entered Korea October 2000 for a short-term visit. What a surprise. He overstayed and worked in a factory. He started to go to a certain church, we're going to call it B Church, nothing to do with Mr. B before, because he had an invitation from a friend. And he then registered as a devotee of the church, I guess that means a member of the congregation, in 2006. So we don't quite know how long he went to the church, but you can infer he started going sometime between 2000 and 2006. So maybe by 2006 he'd been going for a few years. He converted to Christianity, was baptized in 2010. Now we know for sure he was going to the church for 4 years before being baptized. 2016, he's arrested by the Korean Immigration Service, receives a deportation order. He lodges a refugee application from a detention center where he was detained. And Sujin, you're going to need to help me with this, but the detention center refused to submit his refugee application because he had not lodged it until after he received the deportation order. And he had not been actively and publicly involved in religious activity, and so was not likely to be a subject to what is called persecution if returned to Iran. Now, did he actually lodge a claim in the end? Do you know what happened? Because somehow this has got to the court as an appeal.
He lodged it, and this is a claim about the cancel his rejection or not lodging his refugee claim. So detention center refused to submit it, and later on they submitted, but they rejected it. So this is about canceling the detention center's result or decision,
Yep.
not accepting his refugee
Okay.
claim.
Okay, I understand.
So the lawyers work it.
Application was later accepted.
Right.
Submitted.
That makes sense, and I understand it now. Because you've all read the decision and you've spent the day carefully studying it and poring over it, and you went without lunch so that you could read it in more detail, you tell me what's the really good thing that the court did here? They're all sitting there going, don't ask me, don't ask me, don't ask me. Look at the dates. He's been in Korea for a staggering length of time. He doesn't apply until he gets a deportation order. This is what upset the detention centre. Do you understand why? Because I've just talked to immigration officers about this afternoon, so I am locked and loaded, ready to give you the answer to this. What I said to the immigration officers today, and I say to you now, we all know, because we're told by our dentists and our dental technicians, we're all told that we need to see the dentist about every 3 months for what do they call it, a scale and clean, and once every 6 months to be checked for a filling. Put your hand up if you can honestly say that you voluntarily go along every 3 months and get your teeth cleaned, and then you go along every 6 months and have your teeth checked for fillings.
Don't put your hands up all at once. One. Yeah, you do. Good.
There's always one goody who
Yeah.
does. Look, the truth is, it is human nature to avoid doing what is stressful and unpleasant. We put it off. It doesn't make us liars. It just means that we are inclined not to tackle things that are upsetting or stressful if we don't have to. And applying for refugee status is extremely stressful. I hope never in my life do I have to apply for refugee status because it is a traumatic and difficult experience. I see what people go through on a daily basis, and to speciously say that because a person didn't claim for a long time or until they were picked up to be deported, that is such shallow thinking. That is failing to understand the human condition. The court here had a further very, very good response to what had been said at first instance. Get real. This guy was not a committed Christian until about 2010. So it's only around about then that he would have been starting to consider the impact of his conversion to Christianity. It is, being baptized is making a commitment to Christianity, to your particular branch of the Christian faith. And that is not 16 years ago. That is 6 years ago. That's a far more acceptable period of time to just put your head down and carry on working and hope nobody ever notices you. And the court was very clear to find this. It is possible the plaintiff delayed lodging his refugee application to reduce any risk. and therefore solely on the reason that the plaintiff delayed his refugee application submission, cannot make a valid claim to deny his claim on conversion. Sujin has given us a couple of extra points today. The first is have a look at what the Korean court said about persecution. This is good, clear thinking about what is at issue. Being persecuted is an act that will put one's life, body, or freedom at risk, as well as serious infringement of or discrimination on human dignity. Now, it's not quite the language that we would use in New Zealand, but it is grappling with the right concepts. Human dignity is Asian speak for human rights. It is an encouraging sign to see the courts accepting this broader notion of what being persecuted is. I mean, here we are grappling with Japanese cases that talk about a threat to life or freedom because they're hung up on Article 33. This, not so very far away, is being addressed, I think, in a much more encouraging way.
You may recall yesterday, there was a case that we looked at for a Nepali it was a Nagoya case, it's on the second page, the one at the top, where the judge there actually did go down a similar path to this, if you recall. Yeah. And he quoted from the preamble, he quoted from the UDHR and the handbook, and seriously went down this track that was what it was all about. He granted the thing, he didn't go on to say that this is really what persecution is, but it's the furthest I've ever seen. I don't know if it's ever happened anywhere else. So occasionally you do get, in some of these cases, that this
glimmers of hope.
Glimmers of hope, as I say, light at the end of the tunnel.
And lastly, Sujin has given us a really nice little summary of the things that the court felt needed to be looked at to make a decision. If his statement is consistent and convincing, how he or she entered Korea, how long did he or she take until lodging the refugee application, and it is legitimate to think about that. Many people who are not genuine refugees do put in a claim at the last minute to try to buy more time. Don't misunderstand me, I'm not soft. We get plenty of people in New Zealand who put in a false claim at the last minute to buy time. My job is to learn to tell the difference. COI, the level of subjective fear, I don't think that should be there. It does not matter how much subjective fear the person has. And I can prove that to you in 1 second. If any of you think that there is any subjective element to the test for refugee status, just because it says the person has a well-founded fear, I invite you to consider this. I come in to your tribunal, because you're the judge. I come in with my friend Allan, and I've put in a refugee claim on his behalf because he couldn't sign it. I signed it with his thumbprint. We both come from Syria, and he was tortured by the Syrian police so badly that he is now effectively brain dead. So I'm not picking on you, Allan. But just imagine that this is true. He cannot do anything other than sit there and smile at you, and that's the level of the awareness of his surroundings, okay? And I do the talking for him, and I explain what happened to him and how we managed to get him out of the country, but they're still looking for him because they want to finish him off because he was an activist. He does not have any subjective fear of going back to Syria. He can't even contemplate going back. He doesn't know that he is at risk if he goes back. He he genuinely, provably does not have a subjective fear of being persecuted. Are you going to decline his claim for that reason? Why not? He doesn't meet the test. The test says he has to have a well-founded fear of being persecuted. He didn't have a fear of anything. You're going to send him back? Disabuse yourself of any idea that the word fear means he has to subjectively foresee a risk of harm. It is not relevant in the slightest. And I would hope every single one of you would grant him refugee status.
It's totally an objective test.
Yeah, yeah. So this is why in the Korean decision where it says the level of fear the local person would feel in the same situation, I wish the court would step back from this language. I don't think it means what it says. I think they're trying to say the level of risk the person would actually be exposed to, but it's not helpful to use the fear word. Just stay well away from it in all your deliberations about refugee status.
But it's used here, the same ordinary person and this sort of
Yeah,
thing.
yeah, it is.
Crazy.
People feel it's legitimate to use because it's in the convention. I can tell you, the drafters of the convention in 1951 would be horrified to think that anybody would base a refugee status outcome on whether the person actually was in some kind of fear or subjectively, or had to show that they had a subjective fear.
What's two uses of the word fear? That's the trouble. You know, I fear it will rain tomorrow.
Just means I apprehend it will
I
rain
apprehended
tomorrow.
it. That's what it means here.
But we actually can go further, because our brain-dead friend Allan, he can't apprehend anything. He doesn't know he'll be killed if he goes back. But I can assume from the looks on your faces that you're all going to protect him. No. Never have been. 1969, when they passed the optional protocol which took away the temporal and geographical limitations on the convention, that is the only time it has ever been changed. And please don't go around suggesting that we open it up to be changed. The first thing that would happen, 170 odd countries would walk away from the Refugee Convention. It is there, they are locked into it. It's the best we're going to get. Yeah.
That is why last year, December last year, United Nations just approved the United Nations Global Compact on Refugees to complement, to update. But this is a soft, not hard law, just kind of a recommendation.
It's a clever way to step around this very problem, to try to develop a secondary system going along with it. But everybody who works in refugee law knows if they opened it up to revision or change or updating, we would lose it. Nobody would ever agree on what it should now say. I know we are talking about them having a subjective fear, but in this instance, it is about what will objectively happen to them because they have that fear. So if your person is deeply traumatized, and we often see this in New Zealand, we get people, they almost can't talk to us, they are so traumatized. We have psychologists' reports, and for this person to go back and try to put up with what an ordinary person could put up with might very well tip them over the edge. It is, I know it sounds like a subjective fear, but it's not. It is one of their objective characteristics that you are assessing as part of the total package.
So it's an objective assessment of their subjective situation. So if you say a person with this type of profile one with PTSD and the other, objectively you're going to say there'll be a different result, and that's correct. There's nothing wrong with that. They just happen to be one is going to be far more affected by it, because objectively, if you look in that country, then they treat people like that, for example, terribly, or they put them in mental hospitals or what have you, so that you haven't got the same profile between the two.
There was a case in New Zealand some years ago when a man from China who had moved to Hong Kong came to New Zealand in 1996 and lodged a refugee claim. And he said, I grew up in China. During the Cultural Revolution, I was classified Black 5. I was thrown into a Laogai camp, and they worked me for 30 years until I was completely broken. And then they threw me out, and I made my way to Hong Kong. And next year, China is taking over. I can't live under them again. I just can't live under them again. They did such terrible things to me. I don't want to live under them again. I fear that they will do it again. And a different member of our tribunal made a decision and said, you're not a refugee, because although you most definitely do have a subjective fear, and there's no doubt it's sincerely held, objectively, nothing is going to happen to you. The Chinese have got no interest in you. They released you from the Laogai camp many years ago. They've never shown any further interest in you, either when you were still in China or in Hong Kong. And if you go back, I know you don't want to, but actually objectively you're not at risk of harm. My problem with that decision is, I don't think it adequately looked at what the effect on this man, with all of his characteristics, might have been. I don't know if he went back to Hong Kong and killed himself because he was so traumatized by his fear of having to live under the Chinese again. It's a case that has always troubled me. I mean, technically, correct. I'm not sure that the decision maker shouldn't have gone further and tried to get psychiatric evidence about quite how bad life would be for him under the Chinese.
Yeah, 96.
Yeah.
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 Yep.
Difficult cases. It's much easier in Liberia. FGM. Not everyone in this room is at risk of FGM, but for those who are, it is a profoundly serious issue. The plaintiff is a 14-year-old, I guess she's a girl at 14, born in a refugee camp in Ghana, who entered Korea with her mother in 2012. The plaintiff's mother applied for refugee status on behalf of the plaintiff, claiming that if the plaintiff returns to Liberia, she must join the Sandy Bush School and receive female genital mutilation. The immigration officer did not recognize the plaintiff's refugee status because the plaintiff's mother's refugee status cannot be recognized. Therefore, the immigration office decides that the plaintiff cannot be recognized as well. What's the first procedural problem here? Refugee status is personal. We learned this quite early in New Zealand. We made the mistake early on of saying, well, if the husband lodges a refugee claim, the wife and the children can be included. And that was a terrible thing for us to do. It meant we never looked at the circumstances of women and children, who, frankly, quite often, women are more honest than men, have their own specific problems which deserve every bit as much consideration as men's problems, and children have their own problems. When we realized what we were doing, that we were just glossing over the issues of the majority of the members of a family, we changed our system. We make every single person, a 2-month-old baby, and there's somebody who can't tell you that they apprehend that they're in fear. Everybody puts in a separate refugee claim. The Korean government should not have allowed this to happen. The mother and the daughter should have put in separate claims. The court, in fairness, the court sorts this out. The court says, don't be stupid. This is a claim about a 14-year-old girl who says she's at risk of harm. Let's just cut through the procedural nonsense and deal with the substance of it. Excellent. But you can see the knots you tie yourself in if you don't consider everybody's claims separately.
It's mixing immigration with refugee protection again. It's just the same thing. It's the immigration mind thinks, oh, do the family together.
Family unity.
Family unity, and it's just not right.
Well, we've had cases where both parents have failed, the child has succeeded, and the whole family has ended up being able to stay in New Zealand. Many, many times, the lying husband's claim has failed. The wife's claim has been accepted. Her issues, her experiences, and her predicament is different. And it is a grave mistake to just lump family in, usually behind the man. You tell me what I'm supposed to do when I'm sitting in a hearing and I've got an Islamic man from a very devout Islamic background, and he's sitting in front of me and his wife's sitting there as well, and I'm thinking to myself, how do I know if she's got information that she needs to tell me, but she's not allowed to talk to me alone because as an Islamic woman she can't be alone with a man who's not her husband, and she's got things that she can't say in front of him. She can't say in front of her husband that she's been raped. These are terribly difficult cases to work with. Where we get cases involving women in New Zealand, we always try to have a female member of the tribunal, female interpreter. It is a reality that women from many cultures are only able to talk to other women about certain issues. And that's, I don't have a problem with that at all. I will do anything to facilitate the ability of someone to impart what their predicament is. I don't take it at all as an issue if we need to have women hearing women's claims. And somehow, in cases like that, I've got to work out a way to separate them so I can get her evidence alone without her husband hearing it. And how am I even going to know that she's got stuff she wants to tell me but not in front of her husband? I've got to somehow divine that might be the case and give her the opportunity. These cases are really hard. So,
But
back to Liberia.
One question, in this case, what is the reason for the one of the 5 reasons for, is a social group or any?
We will come to it.
Okay.
It's important. It's important. It's actually incredibly important.
Yeah.
We will come to it. But first of all, do you know what the Sandy Bush School is? Look, all across West Africa, there are 2 secret societies, one for men, one for women. The Sandy Bush School is for women, the Pora is for men. And these are like, not quite like Freemasons, but the point of them is to support each other. So if you are a woman who belongs to the Sandy Bush School and you need help, there will be people you can go to for help. And it's a status symbol as well. It is a badge of honor. Men want to marry women who've got the status of being in the Sandy Bush School because they are highly respected in society. And it is a secret society. Men are not supposed to know very much about it at all. But if you are accepted into the Sandy Bush School, and note my language, if you are accepted, one of the things they will do to you is FGM. There are problems about whether something like FGM performed on a 14-year-old girl is a breach of her human rights. Can you consent to being harmed? Well, if any of you have ever had a tattoo, which is not common in Japan, I know, but if you did, apart from being a member of the Japanese mafia, you would know how painful it is. And every second young person I see has got a stud in their nose or their lip or their navel. Women wear wear earrings, that a hole has been pierced in their ears. All of this is harm to the body that people consent to. You can consent to physical harm without it being a breach of your rights. And then along comes a 13-year-old girl and says, cut me. Very difficult. I do not have an answer. Every case is going to turn on its own facts. Notice the mother has brought her in. We don't really know from all of this what the girl thinks. Let's assume that she doesn't want FGM. There's a big hole in this case.
How about the case of boys or circumcision, especially Jewish?
Yeah, well, there's been a few of those cases. Not here, in the UK we had them.
Yeah. Look, I said before, you apply to get into the Sandy Bush School. Lovely, beautiful question. We were, like Yasu's question about convention reason, can we come back to that? It's also very important. But the first thing is, who's forcing her to go? The Sandy Bush School is not running around grabbing every 14-year-old girl they see. You have to apply. They won't take you unless you're you're considered suitable. So I'm not quite sure why she's at risk. I had a discussion with Allan about this the other night, and he raised a very, very good point. One of the things you would have to ask about here, the mother. What pressure would she come under to make her daughter go to this school? Because this does happen to women, that they are bullied or forced by society into doing things that they don't really believe in themselves. I've got no doubt in Korea, this woman does not want her daughter to undergo FGM. But back in Liberia, with the pressure of every other woman in the village saying, why hasn't your daughter gone to the Sandy Bush School? Is there something wrong with her? Yeah, I don't, so you would have to explore all of these things. And unfortunately, I don't know that this happened in this case. I think it was just accepted that she was at risk. And that's fine. I'm not going to complain. If Korea protects a girl from FGM, I'm not going to be grizzling about technicalities. But here in this room, we can have the discussion about the application of law. Let's come to two more points. First of all, let's deal with Yasu's thing. What's the convention reason? Just young woman would do. Yeah, adolescent female is fine. I have no problem with that. But I want to put a thought in your heads. I want to leave it in your heads to fester and turn into a fine wine and one day become a bottle of Bordeaux that you will reveal at some gathering of refugee lawyers, and you will impress them with your wisdom. Why do we keep consigning the predicament of women to the particular social group category? This girl is at risk. Let's just assume she is at risk. She's at risk because Liberian society requires that girls undergo FGM. Her family will be compelled to ensure that she goes along and has this done to her because of what would happen if she said no? One of two things. She would either be forcibly made to undergo it, or her family would be ostracized from the village, their status would be rubbish. This is all about an imbalance of power. This is about the status of women in society. Stop thinking about politics as being what goes on in the diet. Politics is about the imbalance of power and the fight for power. That's what it is about. And at a village level, this is the product of political opinion. She has a different political opinion. I am not going to go along with tradition and have you cut me. I am going to make up my own independent mind. I am going to defy the village elders who expect women to be cut. Don't tell me that's not political opinion. So why is it that every time some issue comes around that it concerns the predicament for women, we just turn to the social group category? If we were honest with ourselves, we would look much more critically at why women suffer particular predicaments. The life experience of a woman is quite different to anything I have ever experienced. But I can see objectively what the reasons are for the predicament that women find themselves in. And yes, it is usually a problem caused by men. And it is usually to do with the imbalance of power. So, next time somebody says to you, oh, women, particular social group, I hope that wine has been just maturing in your mind and you bring out a glass of profound wisdom. Because, and if I am critical of women, it is that they don't speak up enough about this themselves. This is your fight. I feel a fraud standing up here talking about why women need protection. Women are perfectly capable of standing up and talking about their own need for protection. So please do it. There are incredible women out there in the academic field like Michelle Foster, Penny Matthew, Heaven Crawley, Helena Kennedy, Lady Hale. These women are champions of human rights. Yet oddly, I don't, in all their writing, I don't see any of them confronting this issue. It puzzles me. And I think it's a reflection of the fact that the convention has too long been interpreted by men. What else do we know about this case? State protection. It's not really addressed in the decision. Again, I'm not going to beat up the Korean judges who protected this girl. But properly addressed, I don't know what the attitude of the Liberian authorities is to the Sandy Bush School. Do any of you? No, of course not. Liberia is a long way away and I've never been in the bush there. What are you going to do about it? You're the decision maker. What are you going to do? Yeah, absolutely. Yes. Not a word, not a word. We're just told about the Sandy Bush School. They don't even describe what it is. Why do you think I know what the Sandy Bush School is? No, yesterday I Googled it. We can't all know everything. I was fascinated to read about it. I didn't have enough time to find out what the Liberian authorities think of it, and these things are often quite difficult to find in the COI. But there will be people like the Red Cross who actually deal with this issue on the ground in West Africa, who will know a fair bit about it. We are talking about Liberia. I'm not expecting that there are sophisticated state protection units to help 14-year-old girls. They're more likely to be told to bugger off to the bush and get it done. Yeah.
Exactly.
Yeah.
That means no state protection.
This case, I submitted COI. I submitted few COIs with Sandy Bush School and similar claims. I think this is one of the cases that I submitted COI, and a lot of reports about this FGM practice in Liberia is found by a lot of human rights entities, including ICRC and other special entities that only focus on the matter of FGM in Western Africa. And unfortunately, there were not much, if my memory is correct, there were not much of the information about this practice of FGM in Liberia. They usually focus on Ethiopian case compared to Liberia because it's much more prevalent in Ethiopia.
And the human rights monitoring in Ethiopia is much more extensive than it is in Liberia. Liberia is a hard country to get to, not easy to live in. Yeah, you're quite right. Sujin, thank you. I hadn't realized you'd put in a submission on it.
This case and Iranian case, that's the case I submitted.
But in spite of you putting it in, the judges don't grapple with it. I mean, I'm actually not really trying to be critical of the judges, because the cases are grants. And sometimes in a grant, you don't want to give... Less is best sometimes with grants. Otherwise, you create problems in the future in other cases. You know, if I, as I've sometimes done, if I say emphatically in a case, you know, well, it's terrible that the Kat Panchayats in India are forcing families to commit honour crimes. The next thing I know, 60 cases have arrived, all about Kat Panchayats and honour crimes. Sometimes the best judicial approach is to say as little as possible, and that may be why, because they're accepting it, they don't feel the need to really get into the country information. Are there other issues about this case that you want to talk about?
That case, Fornar is the name of the case.
Fornar,
K and Fornar.
Yep.
Because my case was the K part of it. But it's and that was Brenda Hale, Chief Justice, the lady I was telling about who gave the brilliant decision in the Brexit case.
Yep.
Fornar, F-O-R-N-A-H. And it's exactly what happened. But I was going to ask, Sujin, in this case, did the mother get refugee status as well?
In the end.
Well, as part of this case or some other way?
No, I haven't actually looked into the mother's case. It's only the daughter's case.
Oh, okay.
But considering that daughter's underage at the time of the case filed, it is the usual that the mother gets similar status, or at least humanitarian status, to the protection of the underage child.
So they didn't do it as a separate case? No.
It's a separate case, actually.
Pardon?
They did it.
They did it as separate cases. Yeah, well, even the separate cases. You see, what happened in that K and Fornar case, they went to the Supreme Court in the UK on this issue, on the FGM issue in Sierra Leone. Also, the mother's case went with it. And because she'd lodged it, but by then they'd converted it into 2 claims. And in addition to that, there were 2 or 3 other claims. That's what it's K and Fornar is the name of the case. And the K case was one that I'd done. And I had said that the law in the UK was wrong in relation to family being a particular social group. The law in Japan and UK for that time had for many years, following a decision in Colombia, said no, it's not. Family is not a particular social group, which just staggered me. How can you not be you cannot get a more fundamental social group than family. And so I wrote a decision saying I wanted to grant this, but because of this I didn't say that, but because of this decision of the Court of Appeal in the Colombian case some years ago, which said that it wasn't, I am therefore bound under precedent to follow it, because I was the next level down. And so, with a little bit of encouragement from the president of our court and so forth, they put 2 or 3 cases of this nature together, took the whole lot to the Supreme Court, and the Supreme Court said, firstly, the daughter qualifies under PSG, and secondly, so does the mother, because of the very thing, almost the political pressure you're talking about. They didn't call it politics, but because she was a member of the same family. And that is also a particular social group. So it's one of the things I was most proud of in the UK, that I was able to get them to change their silly law that had been there And it was partly because I came from New Zealand and never thought of that until one day I had a case, not this case, that came before me, and I was about to grant it, and somebody who was sitting with me said, "Oh, you can't do that. What about the rule in," what they call it, started with V, I've forgotten the name now, of the leading case on it at that time. I said, "What?" So I go away and look this case up and find I would have been wrong. So I think actually I turned those cases down, but a few years later when this opportunity came up, I made sure I went as far as possible and put all the reasoning down and comparisons with overseas decisions and so forth into it. And so that's why I've always had a soft spot for Brenda Hale.
That is it for the discussion about the Korean cases. But I want to, because we've been talking about this issue about the consideration, the closer consideration you should give to the appropriate convention reason, I want to just throw a little curveball at you to see what you make of it. A woman in Iran is being beaten by her husband. He's just a nasty guy. He's a meth user, he's a drug addict, and he takes drugs, he gets very violent and angry, and he beats her. He beats other men in the pub. Well, no, pubs in Iran, but down at the souk. He's a very violent guy. She goes to the police. They say, "Go away. This is between you and your husband. Go and sort it out." She comes to Japan. She claims refugee status. She turns up before you. You're quite happy with her credibility. You're quite happy that if she goes back to Iran, she is at risk of harm from this maniac. What's the convention reason? No, not particular social group.
Where's the innate?
He beats up, but he beats up everyone. He's not picking on her because she's a woman. He's just a nasty bastard. He's a drug addict. He's violent. So it's not because she's a woman. This is not about divorce. She's not going to have time to worry about divorce. She's going to be dead if she goes back. This is about this. You really think restraining orders stop violent men beating women? What planet? Canada gave refugee status to a New Zealand woman because she could not escape her violent husband. They were right to do so. Correct. No state in the world can guarantee to protect all of its citizens all of the time. And when you have a violent man who is not put off by the fear of the police and the court system, but he's going to have his revenge, and you will read about men like this in the papers every day, then no, not the New Zealand police force, not the Japanese police force, or the Korean or the Austrian. Well, first of all, that may happen. A country's surrogate protection is not an absolute guarantee against safety. And it's a problem in a country like New Zealand where we have an open border with Australia. Australian women come to New Zealand to escape violent men, and their husbands are able to follow them. It is a problem. And our two countries need a better system of monitoring violent husbands. But we're straying from the issue of the convention reason. Absolutely. If we had to go there, absolutely. You are perfectly right. But what I'm saying is we don't have to go there. You are starting to get there. You are starting to get there. What do we need? Harm plus absence of state protection. Convention reason. it can attach to this, but it can also attach to this. Why would the police not protect her? Because for religious and political reasons, women in Iran are second-class citizens. They denied her state protection for reasons of political opinion and religion. And those are the convention grounds that make her a refugee. Nothing to do with the mad husband.
You're very quick to pick that up. That took us about 6 years to work out in New Zealand.
That is true. That is true. Yeah, 10 out of 10. But most countries around the world, they never think of this. There's this obsession, this focus on why the harm is happening. But it's only half of the equation. And this can just as easily attach to this part. So it pays to think laterally if you're looking at a case where you're struggling for a convention reason, just step back from it and think about the bigger picture, and the answer may pop out. I've spoken enough.
Yeah, we're going to have just one question and we'll take a break then.
Yeah.
Yes.
Well, I'll have a go at answering that. It's tricky. There are real issues with cases that are about domestic violence, because most countries around the world, even emerging countries, they do have a form of protection for women. They have domestic violence units within the police, and so everything is going to turn on the facts of the individual case. And just because a man beat up his wife a couple of times sometime in the past, you need to look at not what happened in the past, but what's going to happen in the future, just as you would with any other case. And not all men who commit domestic violence go on harbouring the feelings of anger or frustration or resentment or whatever that caused it at the time. It is often a feature of the breakup of marriages, and once the marriage is broken up, the parties pretty much go their separate ways. And by and large, most men are sufficiently intimidated by the presence of police and a court system that would jail them, that once the heat of the moment has gone, they don't do anything further. The difficulty is in trying to separate those men from the nutcases. And we have got an horrific case going on in New Zealand at the moment where a doctor who is an immigrant to the country is alleged to have been grooming young girls, and when one of them resisted his advances and threatened to report him to the police, a few nights later he allegedly broke into her home and slit her throat with a knife and stabbed her. It was horrific. And the levels of violence that men are capable of committing should never be taken lightly. Men are don't start me on men. It is always better to be safe than sorry. And if you're in doubt, you should grant. Because there are far too many cases where men have given assurances that they'll stay away from a woman only to turn up later, having been brooding on it for weeks or months and do real harm to her. The real chance level is a pretty low threshold. And that's deliberately so, because none of us can predict the future. And protection is not about an absolute certainty of harm. I don't enjoy domestic violence cases. I try not to hear them because almost always it's a woman. I would rather that she talked to another woman than tried to talk to a man. And so This is not me being a coward and ducking out of doing these difficult hearings. I genuinely think it is preferable for women to talk to other women about issues like this. You don't know what will come out of the woodwork. Halfway through the interview, she suddenly starts talking for the first time about being raped. This was never mentioned by her before because she couldn't articulate it. I don't want to be the one that she has to tell it to. I'd much rather it was a woman. State protection? I don't place a great deal of faith in state protection. Police forces and court systems are ambulances at the bottom of a cliff. They're not the fence at the top. It is no consolation to a woman who's been beaten by her husband to say, oh, well, now we're going to arrest your husband and put him in jail. That's not state protection. It may be the correct thing to happen, but it's not state protection.
All right, shall we take a break now and then we can go back and look at some